people that we have the Wednesday meeting at 12:15.
Yep, we are live.
Good morning. This is Senate Judiciary. This is Wednesday, February 8th, 2023. Our first item on the agenda is F4, enacting reducing crimes and violence associated with juvenile dangerous weapons. Our first witness is the Honorable former Judge, or she's still a judge, I guess, Amy Davenport, Vice Chair, but she's here as Vice Chair of the Children and Families Council for Prevention Programs, which I believe there's a House bill that's changing all of the names, but the group will remain the same on the Senate. So, Judge, welcome.
Thank you.
Do you know everybody here?
I don't. It's been a couple of years since I've been
Yeah.
here, so.
I'm Bob Norris, Franklin County.
Just to meet you.
Tanya Bigowski, Chittenden to Central.
Nice to
And
meet you.
Dick Sears,
Yeah.
we've met.
Yes, we have met on many occasions.
Nada Hashim from Wyndham County, Hillsborough, Chittenden Central. Chittenden Central.
And thank you for allowing me to testify. I am here on behalf of the Vermont Children and Family Council for Prevention Programs. I was appointed to that council, and I will refer to it as the council because its name is totally unwieldy. But I was appointed to that council when I retired from the bench at the end of 2014. So it's been, I've been working with them for a bit. And Peggy has very kindly agreed to run my PowerPoint for me because I don't have a laptop. We're here. We initially, I think, sent everyone our response to a proposal that DCF had, a written proposal that DCF had submitted to the legislature on a high-end system of care. Towards the end of that proposal, they stated that they were going to be asking for a delay in the implementation of Raise the Age, specifically that 19-year-olds, some 19-year-olds anyway, would come under the jurisdiction of the family division. And they were asking them for a delay until their entire system was built. Since that time, the administration has come in and asked for a 2-year delay. The implementation was supposed to take, 19-year-olds were supposed to, the 19-year-old charges were supposed to be filed in the courts beginning July 1 of this year. There had already been a 1-year delay. They were supposed to start last year. And the administration is asking specifically for a 2-year delay so that they would come in July 1, 2025. So we wrote a response to that report, and I'm here to testify specifically to the delay and why we think that that delay is too long. But let me explain a little bit about who the council is, who we are. That's the first slide. Good morning. We are the Vermont State Advisory Group for Juvenile Justice and Delinquency Prevention. Every state is required to have what's known as a SAG, State Advisory Group, by federal law in order to receive funds for delinquency prevention from the Office of Juvenile Justice and Delinquency Prevention. 21 members were appointed by the governor, confirmed by the Senate, were attached to DCF for the purposes of planning and administrative functions. And our chair, who's not here today, is Karen Gassine, but some of you may remember she was very much involved in the initial Raise the Age legislation, Act 201. What we do is we provide grants to community partners related to juvenile justice and the prevention of juvenile delinquency. Vermont receives used to receive around $400,000 a year for this purpose from the federal government. But thanks to Senator Leahy, because we're a small state, we have the minimum allotment. We now, the allotment was increased last year to $600,000. We have funded projects to try to support the implementation of Race and Age. For example, we provided a grant to the crime research group to measure the recidivism rate of 18 and 19-year-olds prior to Race the Age. So the 18 and 19-year-olds who went through the adult criminal system, so that we would get a recidivism rate, and then we could compare that sometime in the future to what's the recidivism rate going through the family division as opposed to the criminal division. I think as Senator Sears pointed out the other day, this is a population that has a very high recidivism rate, close to 50%, depending on how you measure recidivism. But if you measure recidivism as getting another charge within a 3-year period after your initial charge, they have a relatively high recidivism rate. We've also, and I think you heard about this from Christopher Lukasik, who's also a member of the council. We've also funded a domestic violence accountability program. We funded Bennington College to develop recommendations for a program, and we're in the process of putting out an RFP to actually fund a pilot of that program. One of the things that changed as a result of Race the Age, when you now have 18 and 19-year-olds in the system, prior to Raise the Age, if you're dealing with 15, 16, and 17-year-olds, if there's a domestic violence charge, that's usually a youth versus a family member like mom, a dad, a aunt, or uncle. But if you are, but once the 18 and 19-year-olds come in, you then have charges that involve intimate partner violence. And Vermont did not have a good program for that age cohort in domestic violence. We also, part of our charge from the federal government is to reduce racial and ethnic disparities, identify them and reduce them, and to support the DCF's compliance and monitoring with respect to the core requirements of the Juvenile Justice Reform Act. So as background, I gave a little background to start with about the proposed delays in implementation of the 18 and 19-year-old, or the 19-year-olds coming into the juvenile system. I just want to reiterate that we are very cognizant of the DCF staffing issues. The DCF has the same kind of problems that teachers have, law enforcement has. As a result of COVID, they lost a lot of their staff, and it's been difficult for them to fill vacant positions. But the council's view is that 2 years is too long to completely delay the implementation of Raise the Age. Almost 65% of the charges involving 19-year-olds that were filed in the last year were misdemeanors. So we have some data on that, and let's see if we can go to the next slide. So if you look at the court filings on 19-year-olds, you see that and these are federal fiscal year, because since we receive federal funds, we operate on a federal fiscal year, which starts October 1 and goes just at the end of September. We just completed, at the end of September of 22, we completed federal fiscal year 22. So this is fairly recent data. There were 134 cases filed involving 19-year-olds. 86 of those cases were misdemeanors. And of the felonies, there were 48 felonies. Approximately half of those were Big 12 cases that would, in any event, be filed in the criminal division because they're in the Big 12. To us, the data on 19-year-olds doesn't really support keeping all of them from, particularly the misdemeanors, out of family division. The misdemeanors, the kinds of misdemeanors we're talking about here would probably go to diversion. If they were cases filed in the family division, they would be confidential as opposed to public. So we also looked at data on, because there were a lot of discussion about the increase in violence among youth, and particularly increase in violence with respect to firearms. We also looked at the data from the perspective of looking at offenses that involve firearms. And those offenses range from very serious, Big 12, aggravated assault with a deadly weapon, to probably somewhat less serious. I think there was one of these, having a gun or having sure there's a firearm or a weapon on school property. So it's a range of different types of offenses. Most of them, though, are serious offenses. Most of them are in the Big 12. The only exception I would say to that are aggravated domestic assaults are not in the Big 12 right now, and there are some, those are can be charged with as aggravated domestic assaults with a weapon. So you all recall that beginning at age 14, if you are charged with a Big 12 offense, that means that your charge gets filed in the criminal division, except with one exception. If the state's attorney decides that this youth, even though they're charged with committing a very serious offense, really should be treated as a youthful offender, the state's attorney can choose to file that charge in the family division as a youthful offender charge right from the beginning, as opposed to, you know, filing in an adult court and then having it moved to the family division. And I know you've heard a lot about that moving back and forth business, but the state's attorney can choose initially to file in the family division, and they would file as a youthful offender because it's a Big 12 offense. So looking at the filing data, first, the filing data in the family division, and this is only involves offenses that are with a weapon. So when you look at we divided it up into the 12 to 17-year-old cohort and then the 18-year-old cohort. And when you look at the 12 to 17-year-old cohort, you see a jump from federal fiscal year 21 to federal fiscal year 22. It went from 6 to 20, which sounds like a lot. It is a lot, but keep in mind, these are offenses that were initially filed in the family division. So all of those 20 offenses, to the degree that they are Big 12, they are offenses that the state's attorney decided from the get-go to file them as youthful offender cases in the family division rather than filing them in the adult. Also, I have to put that number 20 in context. That's 20 out of something like 500 or 600 cases involving delinquency cases involving 12 to 17-year-olds. So you're talking about 4% of the charges. In the 18-year-old cohort, which we kind of carved out separately, just because it predicts more maybe what 19-year-olds would look like. It went from 7 to 8, which is kind of the normal kind of fluctuation that you would expect in between the two fiscal years. And then we also looked at charges involving weapons that were filed in the criminal division as adult charges. These would be Big 12 charges, right? And we looked at the same cohorts, 11 to 17-year-olds, or 12 to 17-year-olds, and then 18-year-olds. And there is a jump. 12 to 17-year-olds went from 5 offenses with a weapon to 8, and the 18-year-olds went from 8 to 11. But remember, these are all in the criminal division. So they are going to, unless a motion is filed to remove them to family division, to have them treated as a youthful offender, in which case the family division could not find them eligible for youthful offender unless they find that there's a low risk to public safety and that they're amenable to treatment. These cases are going to stay in the adult court, which is probably where they belong. So in conclusion, we believe that we need to move a little bit more um, uh, quickly to implement having the 19-year-olds as part, with the exception of the Big 12 offenses and some of the offenses that you have laid out in S4 would probably become Big 12 offenses. But we believe that the 19-year-olds, certainly the misdemeanors, those cases should not be delayed. The data just doesn't really support a long delay, certainly not a 2-year delay.
I would agree, but I will say that there's a mess, and that is, I think the legislature and the administration is to blame partly for the mess. It's been created by the lack of good planning when plan B, I would say, when Woodside closed. Plan A was to have everybody, that was at Woodside who were serious offenders go to Newberry. Newberry didn't pan out, and I don't want to get into debate about why, but there is no bottom line. Then they tried Sonoma with New Hampshire. That has not worked out. And we, the legislature, haven't pushed the administration enough, in my opinion. And I include myself in that, to develop these alternatives. And they did develop some alternatives to the 18-year-olds, but they have done little on the 19-year-olds, instead concentrating on those that are under. So we can keep delaying this, and I think we'll get asked to delay every year. It'll become a yearly event. Last year we got asked to delay. We delayed by a year. This year I think most of us would agree that they're not ready. But whether it's a 6-month delay or a year's delay, certainly not. I would support 2 years. But I do want to. Do we have figures on domestic violence?
We do.
You said that.
We can get I can get you those figures. I have them, but I would
How
take
many
me a
of
little bit
those,
to compute.
14 to 19-year-olds
I can get you
are
the,
involved in domestic violence? What I'm particularly concerned about is siblings or cousins, whoever the domestic violence is with. The old fist fight,
Right.
Well,
I think, well, first of all, there's
two
a,
brothers fighting. There was a case in Bennington years ago.
I remember this case. the
Yeah,
case of
where
Molly
two
Brown.
brothers got into a
Yeah.
fight. Mother was fed up with the two brothers, so she called the police. She will tell you today that was the biggest mistake she ever made,
Yep.
because one of the brothers was charged with aggravated domestic assault and ended up, for whatever reason, I mean, it's his own, not trying to minimize or anything, but he ended up on probation and then violated probation in other ways and ended up in jail. And the mother felt terribly guilty because she thought she was doing the right thing by trying to stop the two brothers from fighting.
Well, I can certainly get you the figures.
So I'm worried that
Yeah.
that becomes a Big 12 offense.
What about aggravated assault with a weapon? I mean, you could carve that one out.
Well, I think we're gonna carve it to just firearms, but.
Yeah. Or with a firearm, because I think one problem, and I agree with what you said about the mess at the high end of the system. We were completely unprepared for the closure of Woodside, having no place. You do need secure facilities, some level of secure facilities to stabilize and then subsequently to treat. That no argument from me on that one. But I think with the when you have the 18-year-olds, as I said, domestic violence kind of changes when you get into the 18, 19-year-old cohort, and even now with the 17-year-old cohort, because you have couples living together, intimate partner violence, and certainly intimate partner violence with a firearm or with even any kind of a weapon is pretty scary stuff. So I don't think council would certainly not oppose adding that to the.
Yeah, thank you, Judge Davenport. Just two quick questions. One's actually a clarification, which I believe just may have been answered. When you're using the term weapon, is that inclusive or is that, what are we talking about?
Well, it depends on how the state's attorney decides to describe the charge, because what I'm looking at is an Excel spreadsheet with the charges, with the most serious charge. So sometimes they describe the charge as say an aggravated assault with a weapon, and sometimes they describe it as an aggravated assault with a firearm. So
Either or is what we're looking at?
yeah, so if it says aggravated assault with a firearm, then you know that a firearm was used. But if it says aggravated assault with a weapon, then I'm not always clear exactly what the weapon was, whether it was a firearm or not.
So this is rather generic when we talk about weapons. We don't really know what we're looking at here.
We don't know specifically what we included when we looked at those, culled out those charges. We called out both charges with firearms and charges with that just were charges, say an aggravated assault with a weapon. I have all that data and I can get you what the numbers are, but I'm not sure that I can say for sure that the aggravated assault with a weapon was not a firearm. I don't know that.
My question is, other than immediately, what recommendation would you be looking at as far as the year 2025? I just heard Senator Sears said maybe 6 months to a year.
Yeah.
No recommendations on your end on that?
I think the council would feel that is much more reasonable than a 2-year delay or a delay that until the whole high-end system gets built, which could be considerable. I mean, Newberry alone, Newberry is a mess. So yeah.
There is some talk of a temporary facility using modular.
Right. That's their other proposal, right? Using the modular
But better modular than they used at State on.
Well, and hopefully they can cite it without a court case. That's the other problem, is citing these facilities is not easy.
Any thoughts on how we could, if we were to give them a 6-year delay, the committee has, or even 2 years, how do we hold their feet to the fire so they're not back here asking for another delay next year?
It's a hard question.
Any thoughts?
Yeah.
Being a member of the other.
That's a really hard question. I know that you've had regular.
Judges sometimes put deadlines on things.
Right, and I know that you have tried to do that with asking for reports, the sequence of reports. Beyond that, I don't know how you do it. Unfortunately, you don't have the tools, the same tools in your toolbox that judges have.
Yeah. That's part of the.
It's a conundrum, yeah, I agree.
Yeah.
I agree. And the staffing, I think the staffing, especially for the higher end kids, the staffing is an issue. If you don't have staff with caseloads that are way too big.
We had a discussion yesterday about Alzheimer's patients who were involuntarily removed from nursing homes because they're too violent. What do you do with them? Comes on staffing questions are very real today.
Very real. And you talk to schools, it's the same thing, especially with the special ed kids, the kids with behavior challenges, finding people. So I think we see it at nurses. We're hearing the same kind of problems there. So yeah, it's a broad issue. One hopes that post-COVID that people will come back and start to.
But they're not at the rates. I went by a sign yesterday or Monday in Bennington, for Happy Valentine's, surprise your partner with a new job, $20 an hour. I thought it was pretty.
That's great. That's pretty wonderful. That's pretty wonderful. Only in Vermont, right?
Right.
Yeah. Right. Well.
And it said second shift differential.
Thank you very much for giving me the
Thank you.
opportunity. As you mentioned, there is a bill in the House to actually change the council's name, but also to describe what the council actually does as opposed to, I'm embarrassed to say that when I was in the legislature, I was the one who introduced the legislation that is still on the books describing what the council does. And it does not, it is not in sync at all with what the council does 40 years later, so.
No, don't feel bad. When Senator Hardy and I were working on the sheriff's accountability bill, I had no idea that the sheriff could appoint, just say, you as a common citizen need to help me, like an old posse. And it's from Prohibition days, and the wording, we're repealing it, but the wording indicates that you could go and break up, stills and illegal alcohol.
Right.
I mean, the wording is all like a
It's
posse,
amazing.
and I had no idea.
It's like painting a horse, right?
Yeah, just,
Our favorite crime.
and if you refused, if you refused on the alcohol end, it was a criminal offense.
Like jury selection. Theoretically, the judge can go out and pick people off the street for jury selection. And if you refuse, it's a contempt of court. I don't know anybody in all my time in the judiciary. I don't know anybody who ever actually did that.
I've had to do that.
You had to do that. Oh, really?
Fire or the judge,
Oh,
and they told me where to go. It was
oh.
very strategic.
Ah.
It's in Albany City, the post office. Everybody goes to the post office. People just stopping him from work.
Yeah.
I'm giving them someone to care. They're not happy.
I bet you were popular that day.
Yeah,
Good
yeah.
thing it wasn't election year.
Yeah, yeah,
I've done that, yes.
yeah. So, yeah, it can happen.
Well, you never got a posse together, though.
I've never got a posse together.
Not yet.
There's still time.
Those are good.
Well, thank you.
Thank you.
Nice to see you all.
Our next witness is, what did I do with the agenda?
Allison.
Yeah, Allison, thank you. I'll find my agenda soon.
Morning, everyone. My name is Allison Shee, and I serve as counsel at Everytown for Gun Safety, where I am responsible for supporting state legislative efforts in Vermont. Everytown is the largest gun violence prevention organization in the country. We have more than 10 million supporters, including moms, mayors, survivors, veterans, gun owners, and just everyday Americans who are fighting for public safety measures that can help save lives. So I want to thank you all for allowing me to testify today in support of S4. I want to focus my remarks on some of the specific provisions in the bill that will help block illegal gun access at the point of sale, prohibit access to assault weapons by young people who we know are at an increased rate of risk of perpetrating violence, and allocate funding to support community-based interventions that break the cycle of violence in the hardest hit places. First, this bill significantly strengthens Vermont's laws focused on ensuring guns are kept out of the wrong hands. It's simply common sense to ensure that people who are currently fugitives from justice, people who are subject to final domestic abuse or stalking related restraining orders are prohibited from purchasing or possessing firearms. Likewise, it's logical and prudent to ensure that people who are charged with carrying a dangerous weapon while committing a felony, drug trafficking, or human trafficking should be prohibited from purchasing or possessing firearms. I want to particularly highlight the importance of ensuring that those subject to final stalking-related or domestic abuse-related restraining orders are prohibited from accessing firearms. When it comes to gun violence against women, the United States is the most dangerous country in the developed world. Women in the US are 28 times more likely to die from firearm homicide than women in other high-income countries. And while domestic abuse is not just borne by women, it is an epidemic that affects millions of women across the country. And guns in the hands of domestic abusers can turn abuse into murder. Indeed, the presence of a firearm in a domestic violence situation makes it 5 times more likely that a woman will be killed. And incidents of stalking are of particular concern when it comes to the lethality of these criminal acts. A study of incidents in 10 major US cities found that nearly 9 in 10 attempted murders of women involved at least one incident of stalking in the year prior to the murder. And we know that common sense measures like those contained in S4 can help. States that have restricted access to firearms by people under domestic violence restraining orders have seen a 10 to 13% reduction in intimate partner homicides. I know that there's been some discussion in committee about the potential impacts of the United States Court of Appeals Fifth Circuit decision in United States v. Rahimi. And I want to be very clear about what it means right now nationally and what it means and doesn't mean for Vermont. Right now, we're in a moment in time when, in the wake of last year's Supreme Court decision in Bruin, foundational public safety laws are being challenged across the country. We expect that the vast majority of these laws are going to survive the challenges, but we also face this period where we're going to see a lot of litigation. We saw the exact same thing happened after the Heller decision in 2008. And while we think that Bruin was wrongly decided and quite frankly, reckless, the opinion certainly does not mean that our domestic abuse protection should be struck down under the Second Amendment. We fully expect the Fifth Circuit opinion to be reversed if Bruin is applied faithfully upon appeal. We can't know how long all of this litigation is going to take, but it's critical that it doesn't deter or intimidate you from carrying on the important work of passing laws that you know can help keep people safe from gun violence. 31 states plus DC have enacted a law barring people subject to domestic abuse restraining orders from having firearms. All of those laws remain in effect because Rahimi only addressed an analogous provision in federal law. So I'll talk in a moment a bit more about why there's some uncertainty about laws related to firearms in our courts and how we should be thinking when proactively enacting them. But on this particular policy, which is a common sense bedrock gun safety law, you and your colleagues in the legislature should be looking to bring Vermont's laws up to the standards of the vast majority of states, and especially every other state in the region, including New Hampshire, Delaware, Connecticut, Massachusetts, Maryland, Maine, New Jersey, New York, Pennsylvania, and Rhode Island. You actually have to get in a car and drive all the way to Ohio or South Carolina to find a state that doesn't have this kind of provision in their code. So you shouldn't be dismayed by an opinion that, until reversal upon appeal, only impacts the enforcement of one provision of federal law in Louisiana, Texas, and Mississippi, which are the 3 states that comprise the Fifth Circuit. We strongly support Vermont prohibiting people who are fugitives from justice, people charged with particularly concerning offenses, and people who are subject to final domestic violence and stalking-related restraining orders from having access to guns. We are likewise grateful that this bill will help ensure that young people with dangerous histories are not able to purchase a firearm by facilitating the reporting of juvenile records to NICS. And that's going to help Vermont comply with the enhanced federal background check now required under the Bipartisan Safer Communities Act. We also support that this bill would prohibit young people under 21 from possessing assault weapons, which are semi-automatic firearms that have features that increase their lethality or their concealability. Assault weapons are generally capable of firing far more bullets far faster than manual action hunting rifles. In addition, each round fired from an assault style rifle has a muzzle energy much higher than a bullet fired from a handgun. And this means that each round of an assault style rifle inflicts greater damage to the human body than a round from a typical handgun. And these guns can fire many of these high-powered rounds extremely fast. The assault weapons prohibition in S4 will help keep firearms that were designed to be weapons of war and really have no place at all in the civilian market out of the hands of young people. We know that prohibiting assault weapons can save lives, as these laws have been associated with a lower likelihood of an active shooter event. Between 2009 and 2020, when assault weapons were used in a mass shooting, 6 times as many people were shot, more than twice as many people were killed, and nearly 22 times as many people were wounded per incident on average compared to mass shootings where these weapons were not used. A 2019 study also found that while the federal prohibition on assault weapons and high-capacity magazines was in place from 1994 to 2004, mass shooting fatalities were 70% less likely to occur than during the 13 years studied before and after the prohibition. Unfortunately, the federal law was allowed to sunset in 2004, making it even more critical for states to step up and regulate these unusually dangerous weapons. For some context, currently 9 states and DC broadly prohibit the possession of assault weapons. That represents over a quarter of the United States population. This includes nearby northeastern states of Massachusetts, Connecticut, New York, New Jersey, and Maryland. California was the first, and their law has been in place for more than 30 years. The most recent assault weapons prohibition was enacted in Illinois just last month, and I had the honor of testifying in support of that bill during the legislative process as well. We support Vermont's efforts to thoughtfully regulate access to these weapons by young people. But I also want to take a moment to address some of the prior testimony opposing provisions of this bill, which mischaracterized assault weapons prohibitions as having been and are being struck down as unconstitutional. And I want to clarify for the record that to date, not a single assault weapons prohibition has been struck down. And pardon me, I've got one of those February colds, thanks to my 4-year-old. In the Colorado case that was cited by a previous witness, the case was filed ex parte without the chance for defendants to respond. The plaintiffs in that case subsequently dismissed the case and dissolved the temporary preliminary restraining order. And while new litigation has been filed challenging these same laws, there's not yet been a decision on the constitutionality of those laws. But there have, on the other hand, been recent decisions affirming the constitutionality of large capacity magazine prohibitions, which have examined much of the same evidence and considered many of the same sorts of arguments that would be and are currently being relied upon in assault weapons litigation. In a very thorough and really well-reasoned opinion in Oregon Firearms Federation, Inc. versus Brown, a Trump-appointed judge in federal district court found that the historical evidence supported the constitutionality of the state's large capacity magazine law. The same reasoning should apply in an assault weapons law. In fact, the Oregon court considered the Colorado decision regarding the Boulder County ordinance that the prior witness referred to, and correctly noted that it was issued without a hearing or without defendants even filing anything with the court, and thus it provides no guidance on the constitutionality of large capacity magazine restrictions post-Bruin. But I want to highlight 2 important things. First, no one can confidently predict how our firearms laws will be evaluated in a post-Bruin landscape. The Bruin opinion ruled unconstitutional New York's proper cause requirement of their concealed carry permitting law, and that impacted New York and the 6 other states with similar standards. It did not evaluate any other kind of firearm restriction. It did, however, articulate a new text and history test by which all firearm laws will be evaluated going forward. This new approach to evaluating laws will be unpredictable until we see much more evidence of how courts, and in particular appellate courts, who are only now beginning to weigh in, are going to rule. And we've seen in the months since Bruin was decided this wave of litigation around the country, far more than 50 cases at my last count. Last week, we saw one of the very first opinions delivered by a federal court of appeals in applying a Bruin analysis. But we are still a long time away from seeing whether and if there are splits between circuits, and whether and if the Supreme Court of the United States decides to grant cert to resolve any potential disagreements among the circuit courts on any particular gun violence prevention policy. Secondly, and most importantly, I want to zoom out and look at this bill in a national context, because other states that regulate assault weapons and take a much more robust approach, since those states prohibit assault weapons for all ages, not just for young people. In fact, several states block most gun possession by people under 21, not just assault weapons. And this bill's provision is limited to prohibiting only those under 21 from possessing assault weapons. It is a moderate approach to dealing with the realities that young people are far more likely to commit firearm homicide, and that these kinds of weapons can cause far more damage far quicker than firearms without these features. Ultimately, the goal of legislation like this is to save lives, which this bill will do. Lastly, but just as importantly, we are thrilled that this bill would create a community safety grant program for localities to support community programs, or the corresponding $10 million appropriation in Governor Scott's proposed budget to fund it. And we would particularly urge the support of community violence intervention programs. Those are programs that address the full cycle of violence, from acute moments of crisis to programming that serves to address root causes, to supporting the healing process of victims and survivors. This comprehensive community-based approach is particularly needed now. According to reports, in 2022, there were over 25 homicides in Vermont, which would be the highest number of homicides in more than 20 years, according to FBI data. And as Mayor Weinberger spoke about last week, Burlington alone saw more murders in the previous in the past year than the previous 4 years combined, including numerous firearm homicides, as well as more than double the number of gunfire incidents than in 2020. We know that the drivers of gun violence are complex and multifaceted, but this bill represents an approach offering a range of proven solutions to support both prevention and intervention. So I want to thank you today for the opportunity to testify in support of this important legislation. I'm really grateful for your efforts to address the epidemic of gun violence in Vermont.
Could you send us copies of your testimony?
Yep,
Yeah, it's in the
Oh,
record.
you have it already, Peggy?
Yeah, I posted it.
All of the stats.
I
and-
didn't find it. Maybe you did it recently.
I did do it.
Okay, I'll log in again.
Refresh.
Thank you. Are there questions? Yes.
Do you by chance have the statistic on what percentage of the Vermont homicides are domestic violence related handy?
I don't have it handy, but I can check with my researcher and get it for you.
Okay, thank you. I thought it was around 50%, but I don't know that for sure.
Yeah, no, I can definitely get it for you.
Thank you.
I'm particularly concerned about the section on the ban for under 21 possessing high capacity magazines and assault rifles. So first of all, is it written in a way that would withstand challenges that we're not doing something that we didn't intend? That's number one. And number two, could you expand a little bit more on why you think it might pass the Supreme Court rulings against unconstitutional?
Sure. So first, this bill doesn't contain a high capacity magazine prohibition. It contains only the assault weapon prohibition for those under 21. And there are a few reasons, because we know that there are 10 jurisdictions right now, 9 states plus DC, that have full assault weapons prohibitions in place for everyone, not just people under 21. And none of those have been struck down. There is right now, we don't have any cases post-Bruin evaluating the constitutionality specifically of assault weapons, but we have a federal court decision out of Oregon, which I mentioned in my testimony, evaluating high capacity magazine prohibition. And that's a very similar kind of argument. It's going to be having the same kind of styles of arguments, the same kind of evidence that's presented. And in that case, the judge found that the state's high capacity magazine prohibition was fully constitutional. So we expect that an outright prohibition on assault weapons to be fully constitutional. So this particular bill, which is a more moderate approach where you're only prohibiting a certain group of people from having access to those weapons, we expect that would pass constitutional muster. The second piece of it is looking at age restrictions generally. And when you look around the country, almost neighbors to the south in Delaware, they prohibit possession and purchase from people under 21 of almost all firearms, with the exception of just shotguns and muzzle-loading rifles, I believe. And there are a few other exceptions for example, law enforcement and military in there as well. But there are many states in Delaware, Illinois, where possession of any firearm is prohibited by people under 21. So this particular law is like this more moderate version and combination of those, where we're saying, okay, these particular weapons are very dangerous. This group of people is much more likely to perpetrate a violence and homicide. And so we're going to take this approach where these weapons are still legal to possess for people over 21, but not for this particular group. So it doesn't stand out compared to what other states are doing. And looking at the jurisprudence and how it's moving so far, we expect this kind of law to withstand scrutiny.
That's helpful. There is a case in the district that I represent that is challenging the constitutionality, re-challenging the constitutionality, I should say, based on Braun, of the height of our ban on high capacity magazines. And I should know the status of it, but I think they're still in the argument stage. So we'll see what happens with that particular decision. But as courts have made rulings, I understand this weekend or last Friday, there was a ruling regarding somebody who was in possession of marijuana, and a court ruled that the narcotics section that was denying their constitutional rights to bear arms, and therefore the ban on marijuana, which is a little different to me than methamphetamine or some other drug, but those bans are unconstitutional. So this is an environment that we're living in where it's unsure what we believe to be justifiable. Like I fully support your position and all what you said about family violence and domestic violence, etc. But I'm not sure that that's going to withstand.
Yeah, I mean, you're naming exactly the issue. We have a flood of litigation. I've looked at over 50 cases I've seen all over the country, which is exactly what happened in 2008 when the Heller decision came down. We saw a lot of litigation, and we expect, just as after Heller, that the vast majority of gun violence prevention laws are going to ultimately withstand scrutiny. We can't predict, whether and if there are going to be splits among circuits. We can't predict whether and if the Supreme Court is going to take up any particular issue to review. And we may see that some don't withstand scrutiny, but I don't think that should deter you all from doing what you know is the right thing to save lives, especially when you're looking at a national landscape. And with the domestic violence prohibition, 31 states plus DC have exactly that. And the decision in the Fifth Circuit is only affecting this one provision of federal law in those 3 states. In the meantime, save as many lives as you can and give victims of domestic violence as much peace of mind as you can. But ultimately, it would be very, very shocking to me if that did not withstand, if that wasn't reversed upon appeal.
I hope that, I guess, Justice Kavanaugh or Chief Justice Roberts are serious about their dissent. Dissent, even though they voted with a majority.
But that language in their dissent was at least baseline.
Allison, thanks for your testimony. One question I have is if you could talk about the historical analog piece regarding this ban. We've heard a lot about having to find a historical analog. It doesn't necessarily have to be a historical twin. That would be with this new test that would be supportive or opposed to the ban part of this bill?
We've got some resources. I don't have them handy in front of me, but I can provide them with you, provide them to you and send them after. We've got a whole like a bank of historical resources. I believe we sent some to Mr. Fitzpatrick, who I see in the back there. So he might have a link to that as well.
Awesome. Thank you.
Other questions of Allison? Great. Thank you so much, Allison. We appreciate testimony.
Thank you all.
Testimony on this later in the week, I believe. But now might be a good time to chat with Eric for about 20 minutes. Wherever you'd like to sit it, whatever's most convenient for you. I'm the only one that has to turn around, stay down there.
Sure.
Which is fine with me. Um, There's a lot of decisions to be made on the bill, but I think as you're working on a redraft, maybe you could just give us a little recap of, I think the committee has pretty much decided that it's firearms, not weapons, that we want to focus on. If I'm speaking out of turn for the committee, just say so.
Section
I'm on my copy of the bill now.
Might be easiest if you're looking at Senator Sears kind of recapping a little bit to go through the bill from the beginning. And whatever comments or things that folks remember that you might want amended or changed. You know, I can also chime in with what I think I might recollect that the committee, does that make sense to you?
Yep.
All right. So the very first provision, this is the expansion essentially, and this is, I think, what Judge Davenport was referring to a little bit when she was testifying. This is the expansion of the, you know, it's not phrased precisely this way, but it's a Big 12 expansion. So it's 3 additional offenses. And right now, as Judge Davenport indicated, if a crime, a criminal act is one of the listed Big 12 offenses and it's committed by a person who's a minor, then that has to start in the criminal division. If it's not one of the Big 12, it has to start in the family division. And there are ways in which they can be transferred between each other, but the default is the way I just described. So what the proposal here is to add 3 new offenses to that Big 12 list. In other words, if a person who right now, under the law as it is right now, 18 and under is charged with one of those offenses, has to be prosecuted initially in the criminal division. Could be transferred, but that takes a hearing and a motion by somebody, so obviously, and a decision by the court. So obviously there's some process that may or may not happen depending on the individual case. So as the default, at least, it would start with a criminal matter.
Unless the state's attorney makes a decision.
Exactly. I was just gonna say that the one exception to that is where the state's attorney, what they call direct files. That's what they're referring to. So direct file means instead of filing the case as a criminal matter in the criminal division, they decide that it's more appropriate to treat that minor as a youthful offender, which is sort of used to be called, Senator Sears, I'm sure you remember this, when it was first started, it was referred to as a blended sentence. And that kind of gives you a sense of how it works. It's, you allow the person to be treated as a juvenile in the family division so that they can have if they successfully complete juvenile probation, then their records will be sealed and their record will be expunged in the same way it would have been if it were a juvenile. That's sort of the carrot. There's a stick to it, which is that if they don't, then they get transferred back to the criminal division and they can be sentenced as an adult. So it's that's why it's sort of a blended sentence. It's a little bit of a middle road. It's not definitely juvenile, it's not definitely criminal, kind of gives the youth an opportunity to comply with probation and get all the advantages of being treated as a juvenile instead of an adult.
As it stands now, so if this change was made, the state's attorney could make the decision to direct file in family court, sort of jumping over this process. As it stands now, can that happen in reverse? Can the state's attorney make the decision to file in criminal court? So right now, this would presumptively start in, like what we're talking about, these 3 things would presumptively start in juvenile family court.
They would presumably start in criminal court. Oh, you mean right now?
Right now.
Existing, I'm sorry, yes, exactly. Right.
But can the state's attorney make the decision to direct file it to criminal court if they feel like in this particular instance? So it's sort of the reverse of what you just described. Is that possible now?
No.
Okay, thank you.
No, currently, if it's not a Big 12, has to start with family time. Now, again, there's a motion process.
To move it.
Correct.
But if we make this change, there is the possibility that the state's attorney direct files into family court and skips the criminal process altogether.
Exactly.
Okay. I was just trying to understand if
It is.
the inverse were true.
Right, it's true.
I think, well, on the youthful offender part, we're going to be waiting for Marshall Paul and Erica Notich for what they're doing to avoid the ping pong.
Okay.
I think that's exactly right. I heard the same thing. They were working on some.
I hope, can you get an update from them? that
Yes.
We'd like to vote this out eventually this year. Is that clear?
I'll check in and see how they're coming along, agreeing on a way to smooth out that process. So yeah, that's one of the main issues is exactly that. Is there a way to, because one of the problems that happens is that, as I've heard, is the fact that because of this ability to transfer back and forth, is that really the most efficient way to do it in all circumstances? Maybe there's better.
Do you have a copy of do you have a copy of the administration proposal?
Hard copy, I don't have it on.
Can you look that up, Peggy, and
Yep,
make copies
it's
for
posted,
us?
I'll grab it.
Because at the same time, they've got about 27 crimes they want to.
Yeah, I have a hard copy right here, Peggy, if you want to use it. Or you were sending it to Tony and ask for copies anyway.
Yeah. I can- yeah.
Yes, so that's another point that here, that the administration proposal also expands the list of victim offenses to include a number of others. So, that's sort of understanding that where we're at on that is at least trying to see if there's some language coming in to address the ping pong issue. Moving on to section 2, now actually section 2 and 3 are connected. Remember, this is the piece about using a dwelling for purposes of criminal activity. And you may recall I have this, I don't have a hard copy of it, so I won't be able to read it verbatim. But a couple of things that I have here to going forward. So remember, you have an existing statute that prohibits using a dwelling for sale or dispensing of regulated drugs. And one of the issues that was discussed by the committee is that, how basically an owner, a landlord or owner of a building is potential liability. And I think where one of the directions that the committee might have landed on here was to add some language that would say, so along the lines of, proper tracking the language from subsection A, someone who, owns or controls a building, who either reports unlawful activity to law enforcement or files an eviction proceeding shall not be prosecuted under this section. So the idea was to provide some incentive and also an ability for a property owner who's taking steps not to be subject to prosecution. So that was at least what I thought the committee, I think we even talked about that, and said we were going to at least look at some language in that direction.
One thing I just want to voice is, I mean, there's, I have two thoughts on this section. One of them is to hold landlords responsible when they're intentionally using a property as a nexus for human trafficking or drug trafficking. But I also don't want to create a situation where landlords who are well-intentioned become afraid of renting out to different demographics or just get out of landlording altogether and then reducing the amount of housing that we have available from apartments and so on. So one of my thoughts is having a high standard for this and having it just be knowingly. But that's just one of my thoughts, which just wanted to put it out there for discussion eventually.
Do you mean just knowingly as opposed to knowingly or recklessly?
That's what I was thinking.
Yeah.
I mean, recklessly, the definition is deliberately disregarding, I believe, and yeah, is that correct, Eric? Deliberately disregarding.
Consciously, but same idea.
Yeah. And knowingly is having a certainty that something is going to happen as a result of your actions, right? Is that?
Just to pick up on what Senator Hashim was saying, I find myself stopping over subsection 2 there, carrying a dangerous weapon while committing a felony. It's hard for me to even imagine a circumstance where somebody would, or could be proven to know not only that somebody had a weapon, but that they were using it in commission of a felony.
You want section 3 or section 2?
I'm sorry, page 5, section 3.
Okay. I was on page 4, section 2.
Okay,
Yeah.
and I think they're related.
Yeah.
But so, the chain of proof there for the mens rea seems very difficult to run out. That you have to know or recklessly permit carrying a dangerous weapon while they're committing a felony. I just had a hard time seeing how you would prove a landlord knew all those elements. And I understand what it's trying to do. I feel like that would essentially never get used. Whereas human trafficking, I think there are general signs of human trafficking that you could prove somebody recklessly, or it's kind of the specificity and connected nature of that second.
Well, what it's trying to get at, maybe it doesn't
Yeah,
get at, is where I think the landlord also would need to know. So the landlord rents to single mom and her daughter. The mom gets tied up with a drug group and is receiving drugs in exchange for them spending the weekend with her. And they just decide they're not gonna leave, and they put firearms on the table. I don't know if that's a violent act, just putting it on the coffee table. But it's certainly a signal to the mom and the daughter, this is the Bennington case, that, you know, you're gonna do what we tell you and we're not leaving. What are you gonna do about it? So why would we hold the I think I'm arguing your case, why would we hold the landlord accountable? He rented to the mother and the single mom and the daughter, didn't rent to these people that have now moved in using firearms as a threat anyway, whether, you know, so I don't think it would hurt if this wasn't in there. In other words, if section 2
I guess that's where I was going.
covers it, I don't think we need the, because we get section 2 right.
Yeah, so if section 2 remains, we're expanding a little bit the knowingly. And we'd be,
Chances are this landlord had no idea what's been going on this week in that
right,
apartment.
not in that fine grained detail.
Right.
And that's back to Senator Hashim's basic point about being careful that we don't produce liability and risk for people to the extent that they don't want to rent to, you know, people that they perceive to be risky in terms of this behavior. And also the general testimony we had from people who were concerned about landlords, third party. So if section 3 came out, I would not be, upset about that.
You mean that, just so I know, the entirety of section 3, or were you just talking about A2, this is the carrying a weapon while committing a felony?
I think we take the entire section 3 out. This point,
Yeah.
So Senator Sears, if I could, I'm just getting some texts. There's apparently been false reports of a shooting at Montpelier High. And so if you are getting anything about that, they tracked it down and it's not true, but the governor's working on putting out a statement. So.
I don't actually know if my question is fully formed. I agree with Senator Burr that it would be hard for someone to know the fine detail of if someone is in the apartment carrying a dangerous weapon. However, do feel that it isn't important to hold people accountable if they're allowing or participating in human trafficking in their units. So I'm a little hesitant about removing the entirety of section 3.
Can we incorporate the human trafficking component into just section 2, the previous piece? Or is that, should it just be its own section?
It's sort of a in the weeds answer to that. But the reason that is, I thought that originally, the reason it's not drafted that way, because I have to say, oh, yes, it'd be easy, just put them all into the existing statute, right? Well, the location of that existing statute is in the health provisions of Title 18, it's not in the criminal code, and it's within, it's because it's very specific to regulated drugs. Drugs are in the health provision, in the health statute. That's why this particular statute is sitting in there. Wouldn't really make sense to have a human trafficking provision where that statute is located right now.
I see.
Yeah.
So we do a separate, section 3 would just be human trafficking.
Could do that. Yeah.
What do you want to do with the fine? On this section 2?
I think definitely be reduced. I mean, 100, when we look at different crimes,
Thank you.
state crimes, this is the first I've seen one that's that high.
Last time we talked about it, I think you suggested, somebody suggested 10,000.
I think I said 15.
Yeah,
Or did
I
we?
think I said 50.
somewhere like that.
You said 50? So maybe we haven't landed on that.
Yeah, I mean, no one, when people are doing these things, no one says, oh, the crime or the penalty is $100,000. I better not do this. But they say, oh, it's only $10,000. I can afford that. No one, that's not something that really gets processed. So I think that having it more in line with what our fines are for other crimes that are felonies or on the same level, I think would make sense.
What are the fines associated with the underlying crimes we're talking about with human trafficking or drug trafficking? I wonder if it could line up.
Yeah, I'm not sure.
I don't know either, which is sort of to your point.
Yeah.
I don't even know the fines associated, so how am I gonna do that
Right.
calculation of whether or not I can afford it?
I can look into that.
Okay.
I don't know either off the top of my
We'll
head.
get into it later, but I think what deters crime is the likelihood of getting caught. That's a potential fine or even a prison sentence. According to the latest statistics.
So maybe I'll highlight it for now and see what the fines are for the underlying crime.
Put a placeholder at, XX.
Yeah.
Whatever you do. Yeah. See what the underlying, what other crimes we have.
Right.
What is a crime, what if a landlord, what are the fines applicable to landlords who don't keep up their property, for example? Who, maybe civil fines, but to our fines are substandard dwellings and stuff.
Yeah, I don't know. I don't think it's a criminal offense, but you're right. It might be.
I think there's civil,
I feel like we dealt with that in a charter change last year in government operations, so it might be at the municipal level that those are sort of set and decided.
okay, so section 4. What's,
Right, this is based on the federal statute regarding defacing firearm serial number.
is there any, I haven't heard much opposition to this.
There was, Chris Bradley, I believe it was talking about constitutionality of serial numbers. I don't think that that's likely to be struck down.
What's the federal fine on it? This was copied up federal.
It was. But just to follow up on Senator Burke's point while I'm looking for this federal statute, there have been, as far as I can tell, there have been a surprising number of district court decisions already on this seat. And analyzing the constitutionality of the federal serial number prohibition under Brewer. I think that I've seen 4. 3 of them said it was okay, and 1 of them said that it wasn't. And again, these are all district court opinions, as you've heard from several, that they're not appellate court opinions yet. So it's part of this initial, sort of national working out what these rights are going to be. 3 of the 4 said it was fine under Brewer. I don't seem to have the federal fund, but I can check that out too.
Yeah, would you check that out when we come back to it Friday?
I should have a Rebecca from Attorney General.
I mean, we don't know. I don't think we can legislate in fear that something might happen. You know, it's so unknown and this lines up with what's already federal law. And I know that the one piece that of pushback I heard other than the Defender General's is, well, it's redundant. But I see a point in having the redundancy so that we don't have to rely on the federal system. We can in fact act in our state system. So aside from the fine aside, this makes sense to me.
Well, and I will point out that if we rely on the federal system to prosecute these cases, they may not feel like prosecuting or may not have the time. They have their demands as well, and they don't prosecute every case. That's the reason for having a companion state
Yes.
law.
No, I agree wholeheartedly.
I was just gonna emphasize the same point. I mean, I've had firearm cases where it was very, very small compared to what the federal government is dealing with. And, you know, I've reached out to the ATF before when I was a trooper, and they said, yeah, that it is a violation, but you know, it's one pistol. We're not going to be doing anything regarding this. And also, I think it's, you know, we've heard, why duplicate federal law? You know, the purpose is to say that, you know, yes, this isn't acceptable on the federal level, but it's also not acceptable on the state level. And, you know, we don't want people to deface firearms here in Vermont. It's a crime against the peace and dignity of the state, which is what, you know, that's in the Constitution when you're talking about crimes. And that, as well as straw purchases, you know, it's not okay on the federal level. It shouldn't be okay on the state level either. It's my 2 cents.
I will add that, you know, your comment about constitutionality is well taken. We can't go down to the Supreme Court or up to the US Supreme Court and say, is this constitutional or not? So we're stuck with decision, yet we take an oath of office to not vote against anything that is unconstitutional. So we get the best advice we can, and then we make our own decisions. And if there was one area where I would be more concerned with in the bill, it's the 18 to 21-year-old that might be moved. Whether that'll decide, since I co-sponsor the bill, obviously I've supported it, but would I vote for it now? That's the question that I have to ask, and each one of us has to ask. But I think in this one, anyway, that probably not going to be found unconstitutional because somebody's taken the effort to either do a straw purchase or this. I just think that's pretty safe. But
I'm not quite sure what section we're on, 'cause we're jumping all over the place.
we're on section 4 and 5.
4 and 5, okay, so under section 5, I do have a question. It would be under A2 and large letter B, as well are aware that state always has to prove intent. Can someone give me an example of these 2 lines here? If they intend to, what does that mean? How are we going to prove that in a court of law?
You would have to have evidence that the person buying the firearm knows that they've got someone else, they know somebody else who's a prohibited person, right? So they know somebody who can't buy the firearm because they've got a prior criminal conviction, maybe they're a fugitive from justice, maybe, you know, for whatever the list of prohibited categories, that person falls in. They've got someone they know who they can say, hey, will you go buy the firearm for me because I can't do it. Obviously, that's a pretty cut and dry case because you're actually asking the person, hey, I can't do it because the law prohibits me. That's pretty clear. And will the guy testify to it? I don't know. But that's, you'd have to have some indicia, some evidence, some circumstantial evidence that indicates that the person knew that about the other person. And I think it might be, it should have, or reasonably should have, yes. So again, you could prove that with enough evidence that the person had in front of them. In a way, it's kind of, you know, you can sort of draw it because you have the reasonably should know. It's reckless in the landlord context, but the concept is the same. So what facts existed that, and you know, as a prosecutor and a judge, you have to make a decision as to whether or not there's enough evidence to support filing a criminal charge, and then the jury's going to have to buy it. But that's the method that you would have to act.
Just sounded a little gray to me, that's all.
Those are 10 ones, you're right, totally fact dependent.
Did you,
I mean, I'm not quite sure the question, I mean, you were kind of getting at it, which is that it's really dependent on the facts, you know, it's with the reasonably should know standard, you know, it's the thing that I want to avoid is somebody who genuinely didn't know, getting wrapped up in something. And then, you know, whatever evidence exists just kind of ends up being in that gray area where they're caught in something they genuinely didn't have the intention of giving a firearm to somebody is prohibited. But I think the question Senator Norris asked and some of your responses kind of answered my question.
But it's a legitimate policy concern that whenever you have that kind of language, you have to sort of weigh whether or not you think it's appropriate to.
I would kind of wonder if somebody asked me to go into a gun store and buy them 4 pistols. And after you buy those 4 pistols, I'll give you, whatever, I don't know, make it up, you know, some drugs. And that's the trade. And, you know, I would say that probably good chance that this person wouldn't be allowed to buy the guns if he went in on his own.
And I agree with that. But I think we all can assume that if they should have known or reasonably known, then by looking at the intends to, and the section is kind of duplicative to the way I'm looking at it is, I mean.
Testimony from the Bennington police was that the drug dealer's actually in the car waiting for the guy to go in and buy the guns.
And we all
They
agree
got it
with
on video, so I think there's probably.
Another topic, if
Well, I thought we'd take a break until 10:30 and then come back.
on another topic,
bill.
let's take a break.
Another topic.